This is preposterous. This is nonsense. That he observed me driving. That's a lie. Falsus in unum, falsus in omnibus. False in one thing, false in all. The Constitution and my rights are being broken and trampled on.
Here's a rewritten version that sounds natural, engaging, and fully human written. What you're about to see is part 3 of one of the craziest courtroom stories ever featured on this channel. The case of the state of Michigan versus Philip Andrew Liefers. Philip isn't your average defendant. He identifies as a sovereign citizen, meaning he believes government courts have no authority over him unless he personally agrees to it. In part 1, which we covered with Cam, from hearing to the people, things already got intense. Part 2 only added more confusion. But now in part 3, everything takes a major turn. The judge finally gives Philip permission to represent himself in court. While that's protected under the 6th Amendment, it quickly turns this hearing into complete chaos. During the case, Philip questions the court's authority, quotes the Constitution, brings up UCC laws, Treasury bonds, wedding signatures, Albert Einstein, the Book of Ezekiel, and even tells a story about almost being crushed by 6,000 pounds of steel. This hearing goes completely off the rails fast, so get ready. This is going to be a wild one.
Calls the people of the state of Michigan versus Philip Andrew Liefers. This is all right. This is case number 26819FY. We are here for a probable cause conference. We're also here. Mr. Champion has filed documents on behalf of Mr. Liefers. One of those is an affidavit of non-acceptance of court-appointed counsel, assertion of constitutional rights, and demand for self-representation. The other is an affidavit of notice and acknowledgement and acceptance of oath of public official. The other is a respondent's motion to set aside a default judgment. Before we begin today, I'm going to remind everybody of the court rules and local administrative orders regarding the court decorum and procedure. MCR, which is Michigan Court Rule 8.115, states that photography and audio or video recording, broadcasting, or live streaming, except for requests from film or electronic media coverage of court proceedings as permitted under Administrative Order 1989, are prohibited unless approved by the court. Additionally, there shall be no audio pickup, broadcast, or video appellate cases, so that does not apply. I'm going to ask if anybody is recording these proceedings that these please shut off their phones. I'm also going to ask that any phone be placed in a pocket or purse in such a way as it cannot be seen from the courtroom. If you could stick that in your side pocket, sir, I'd appreciate it.
Deep front pocket.
All right, thank you. I appreciate that. So, appearances, counsel.
Lisa Doe for the people.
Robert Hertel for the Defender's Office. Your Honor, Mr. Champion was in Misaki this morning. I'm sure the court also took note that what we, from the Defender's Office filed, we included a qualifier of it not necessarily being endorsed by the Public Defender's Office. I wanted to make sure to stress that.
Correct, I understand that. So, Mr. Liefers, I know, I think you've been in front of me twice, and I think you were in front of Judge Ransom last time. I know your position regarding the authority of the court. To keep matters moving, though, I have to set a time limit as to how long I'm going to allow you to address the court. Hold that thought. I know you always have a concern, and rightly so, as to whether or not we're on the record. My concern is from where you're standing, I'm not sure the microphones are able to pick you up well enough to get an accurate record, and the court reporter is telling me that. So what I'm willing to do for purposes of this case is I'm going to put on notice that allowing you to pass behind the bar and enter into the well, I'm not agreeing to take jurisdiction over you. I'm allowing you to come forward so that you can make the appropriate record that you wish. Because my concern is, even if you project your voice, sometimes the microphones are just these little triangular things on the table. So my concern is they're not going to pick you up. So I would prefer that you come in and sit next to counsel's table. I don't exercise jurisdiction over you by doing that if you choose to come forward.
All right, so thank you.
All right. If you can come up and have a seat next to Mr. Hartel. So, Mr. Leffers, we're already past noon.
Sir,
So what I'm willing to do is, do you think you can state what you want to state within will 5 minutes be enough time?
I will do my best.
All right. So I show we're at about, well, I'll give you, my desktop says 12:05. It looks like the wall clocks say 12:06. And it looks like they're synced up with each other. So go ahead.
No disrespect intended. Are we on the public record, sir?
We are.
And as redundant as it might be, just please continue to be honorable. I am Phil Levers, lawful representative of the estate in question. I want it on the record. Y'all don't have jurisdiction. Your Honor, I voluntarily appear in this court today on special appearance. I move the court to take judicial note of the Michigan Constitution as ratified without subsequent amendments and the U.S. Constitution and your oath to them, Your Honor. What say you?
Well, as I said before, I acknowledge I took an oath to uphold the constitutions.
Thank you, sir. Moving forward, Article 3, Section 2, Clause 2 clearly states that when a state is a party to the case involving a citizen of that state, the Supreme Court has original jurisdiction, which makes these proceedings improper, violate the Constitution. It's the wrong venue. The request that I've supplied, which I have to amend, because now there are extra things added. And Mr. Champion also and RJ at the defender's office refused to allow us evidence. So I'm still being denied due process. Your Honor, for the record, I am making a clear and unequivocal demand to represent myself in this matter. I am invoking my Sixth Amendment right as recognized by the United States Supreme Court of Ferretta versus California, 422 U.S. 806, 1975. And we have read up on the Wiggins. What? McClaskill, that's right. The McClaskill and Wiggins and the implied change in law. I do not accept standby counsel, which affirms my right to proceed without counsel when the waiver is made knowingly and intelligently. I respectfully decline any court-appointed attorney. You all are friends. Y'all know each other. You most recently took this seat, sir. I made friends with a lot of my coworkers in the past. I'm not going to get a fair trial here. Due process is being denied on that as well. I understand the nature of the charges against me, the penalty, and the risk involved in self-representation. I am making this decision knowingly, intelligently, and voluntarily. I ask the court to conduct any required inquiry to establish that my waiver of counsel is valid and to allow me to proceed pro se. Your Honor, I am making a clear and unequivocal demand to proceed pro se under Ferretta. I am not asking for different counsel. I am waiving counsel entirely. They are impeding upon my due process. Jawkins didn't give me anything that I asked for. In fact, he got upset at me, cussed at me, told me to mind my own business, look over this. Jurisdiction is broken. Due process is broken. I'm not being treated fairly. That is my stance. If you want to indict me on a grand jury trial, please do so. Otherwise, this needs to be dismissed with prejudice or full exoneration, or pull the trigger. Let me go up there. I'll talk to them. It's been a pleasure meeting you.
Well, it's been a pleasure meeting you too. When you say go up and talk to them, who do you mean?
Supreme Court
Okay, all right.
on a federal indictment, which as a national, we're in different jurisdictions, sir.
So I understand you want to represent yourself. I have a couple questions in that regard. So first of all, by representing yourself, do you believe that you can conform to the rules of the court, the published court rules?
With that, finding out other things. Most recently about my hometown, the past two judges have been removed by the tenure council. So canon 1 through 5, indeed, it also expresses that you're the guardian. Prosecutor is the guardian. Lawyers are guardian.
Let's stop for a second and break down what just happened. Philip basically ran through the full sovereign citizen playbook in a single statement. First, there's the special appearance argument. Sovereign citizens often believe that using this phrase allows them to speak in court without accepting the court's authority over them. The problem is, courts have rejected this argument over and over again. In the eyes of the law, you either appear in court or you don't. Next comes his Article 3 claim. Philip argues that because the state is involved in the case, only the Supreme Court has original jurisdiction. But that's not how the Constitution works. That section applies mainly to disputes between states or cases involving foreign officials, not criminal charges against private citizens. Now, one part of Philip's argument is actually legitimate. His Sixth Amendment right to represent himself is fully protected under the Constitution. The Supreme Court confirmed that right in the 1975 case, Florida versus California. So while his request to act as his own attorney is legally valid, most of the other claims he raised really don't hold up in court. At this point, the real question is whether the judge will approve Philip's request, and if so, what rules and limits will come with it.
Of our liberties and the constitutional right. So when someone pro se makes a mistake, and even unpro se, the prosecutor is supposed to be there to uphold justice, not pervert it. And that's what this is about. So canon 1 through 5, if I make a mistake, please correct me. If I file something wrong, the clerk has let me and my wife know, okay, well, this isn't how we do this. We can accept an amendment, you write it in, blah, blah, blah. Okay, so I will do the best I can. I am very different since dying, coma, botched surgeries. I'm a permanent head trauma case. My short-term memory, it's gone. So unless I build a consecutive day after day, that same time, every time, I'm not going to remember. And Einstein said, it is worthless to waste brain power on things that you can write down.
So as the independent party here, and just so you know, I don't know how, I'm guessing you've probably done some checking into me, but I don't know. Before I was the judge, I was the prosecutor. Before I was the prosecutor, I was a public defender. So I've played roles in all three parts here. So
I watched your videos while you were a judge. I watched the one of the two gentlemen that were arrested, and you released them. You dismissed their case. They were arrested over off of 13th or something over by a body shop, running meth. But the officers, same two officers that are involved in my case, tandem, like they do most of the times, which is why they were so close together on my case. They had to realize that they had to be closer together after you threw that case out. They broke the Constitution. I watched what you did, and I watched two other videos, which they fully got what they deserved. They broke the law unequivocally. But those two gentlemen, yes, had the Constitution not been broken, you would have been just fine with proceeding forward with not dismissing their case. But on the grounds that the first thing that the officers did, they broke the law, and then they broke the Constitution, which is exactly what's going on here. My wife and I have been involved in several auto accidents where the Cadillac Police Department refused to fill out a police report. There's now $1,000 worth of damages. The lady dragged her vehicle all the way down the whole side of our truck, from the bumper to the front quarter panel. The captain of the Cadillac Police Department and 5 others were there, and they wouldn't write a ticket. So these 2 officers and other officers state, well, we don't have to do anything on private property. Well, this whole thing was on private property. The officer also stated that he observed me driving. That's a lie. Falsus in unum, falsus in omnibus, false in one thing, false in all. And if you begin it by a lie, how can you be credited to be believed at all? So the officer stated that he had probable cause because he observed me driving. That's a lie. Jurisdiction, lies. You're an honorable man from what I've seen.
So where I was going with that is that, yes, I can provide you leniency, but I can't do it in such a way that it's detrimental to the other side.
Correct.
My side, I'm kind of like an umpire. I call balls and strikes, so to speak.
Correct.
So while, yes, I can give you leniency, I can't spoon feed you things as to what to say, what to file, that sort of thing. So I guess my next question is if I do allow you to represent yourself, would you be willing to have an attorney somewhat of counsel where they wouldn't necessarily be the attorney of record, but you would be able to talk to them about, proper, how to properly file something, how to, if you have any legal questions, how to, interpretation of the court rules, that type of thing. Is that something that you would be open to? So you would be representing yourself. You would just be able to rely on them as a reference.
The problem with that, sir, with all due respect, my wife and I asked Jockins for the supposed 14-second video of not our truck. Whether those are the victims or not, that wasn't my truck. In that 14-second video, that wasn't my truck. Now, I do not accept the fact that I had to watch it at the defender's office, and I still have been refused because policy and procedure, because others have put this stuff out on public notice. My wife has had her video of her accident because she had to take up the reins and take care of herself through her job. Nobody knows about that video. Nobody's seen that video. And most recently, we found out a bunch of other things. There's a conflict of interest. And the prosecution didn't say anything. My wife, who was ran over and her legs are destroyed, was made a victim. She's being made a victim again.
That's in this case?
Yes, sir.
All right.
She was removed as victim and placed as a witness.
So let
That's
me ask you, and I understand why we're getting a little heated, but
sorry.
hold on, let me get my question out. So when you say you haven't been provided discovery, do you mean that it hasn't been physically handed to you, but you've had the opportunity to at least watch it?
Discovery, as I'm learning, is a multiplicity of things. And they have specific names.
So let me be more frank, because again, I'm on a time clock here.
Correct.
So
County.
let me just ask you, have you seen the video? Not has it been provided to you, but have you seen at least what they're saying is the video?
No.
Okay. Have you seen the
Because
police
the
report?
Defender's office, while playing it, it stopped. There's an error. And the video was never allowed to be loaded back up and seen past a specific point, and it crashes every single time.
But they at least
RJ stated, he's like, I just watched all of these. I don't understand what's going on.
But they at least attempted to play it for you, and then it crashed,
I wasn't.
presumably.
Discovery means that the evidence goes to me.
No, I understand, but
look
just
over it.
focus on my question for a minute. My question is, were you given the opportunity to at least try to watch the video? I understand there were some technical issues, but did you at least,
Yes.
you were given that opportunity?
Yes.
And were you given the opportunity to review a police report? Maybe not handed, but did you at least, and don't talk about what they told you because I don't want to get into attorney-client privilege, but did you at least have the opportunity to generally say, okay, this is what the police report says, what do you say, and then kind of merge
I
the two?
object. The insinuation of attorney-client privilege against her, please.
Well, I have to be careful of that because I had appointed counsel.
Correct.
So I'm setting that aside right now. So at least by the time that you had counsel appointed, that's what I'm considering attorney-client privilege.
All right.
Not from here forward, just during that time period that you were with either Mr. Jawkins or you were with Mr. Champion.
Yes.
Did you at least have the opportunity to go through a police report? Maybe not being handed to it or handed it.
We're given the addition to the police report. We were given the police report originally by Mr. Jawkins,
Okay.
which at the bottom of the police report, and there's no signature of any witness. It was Officer Dot, right?
All right, Mr. Leffers, I need you to focus on me because this is one of the rules of the court.
Yes.
It's not appropriate for you to be interacting with a member of the audience. And I realize that you're married and you're one, but
Memory.
yeah, I understand. And that's where why I have concerns about the memory aspect and allowing you to just represent yourself on your own. And that's one of the reasons I'd asked that question about whether you'd be open to of counsel situation where they're there for you to talk about the case. Sorry.
As long as it's completely, and if we have to sign an NDA, fine. I would prefer not to. I mean, I have nothing to hide. But if we have to sign a contract stating, I'm not contracting with this, my constitutional rights are broken. I know what lawyers are about. We've read it. Now, that's not saying everyone's that way because there's moral and honorable. But most of them just want that money. And I know where their allegiance lies, just like I didn't know that a judge also has a banker's oath. I didn't know any of that. But yes.
So, all right.
I will do my best.
So it sounds though that you want to represent yourself, but you're okay with having an of counsel position that you can talk with, make sure things are being filed properly and that sort of thing. Not that they're representing you, but just to be able to bounce ideas off, so to speak.
I reserve all rights through equity and trust law and under the Constitution. And as long as that's not violated, I don't have a problem with that.
All right.
That's what I'm saying. Now,
So if I allow you to represent yourself, are you going to be able, again, to comport yourself? Because realize that in the grand scheme of things, right? The Supreme Court's up here. I'm the district court. I'm way down here. There's lots of courts to get through before you get to the Supreme Court for appellate purposes. So a lot of the things that I'm left to decide are necessarily what the law says, what the Constitution says. The Constitution that is currently before me, there isn't, the appellate courts would have to tell me I'm wrong. Do you understand that?
sir, but we could read the Constitution.
No, I understand that, but what I'm saying,
Article 3, Section 2.
but what I'm saying is, because I've also noticed that in some pleadings, you said that you're not a 14th Amendment citizen, but hold on, but yet in the last pleading, you said I was violating your 14th Amendment.
It's a compilation of books.
Well, but
sir.
see, it can't be. So,
But it is,
but see,
actually.
that's where things kind of go off the rails, because you would agree with me, right? That if you are not a citizen of the United States, let's say you go to Japan, for example, all right? Are you not then subject to Japanese law if you're on their land? Whether or not you're a citizen, you would still be subject to Japanese law, correct?
No,
it's not an analysis. It's
It-
you still retain your U.S. rights and citizenship, but the minute you would step into that territory of Japan, you're then subject to their laws.
anything that abrogates the Constitution and its amendments is unlawful.
But the Constitution doesn't apply in Japan, right?
Well, it does. Because what national are you? That's also protected internationally, to the international court.
Mr. Leffers, I will allow you to represent yourself, but I'm just forewarning you that you are going to be held to the same standards and procedures, whether or not you agree with those standards and procedures, because that is what I'm bound by. The standards and procedures that have been set by the Supreme Court, the laws of the state of Michigan. And when I say the Supreme Court, I mean both the Michigan Supreme Court and the United States Supreme Court. The laws of the state of Michigan and to the interpretations and case law of the when it comes in regards to interpretations of the U.S. Constitution and the.
Let's stop here for a moment, because this exchange perfectly captures the entire situation. Philip argues that he is not a 14th Amendment citizen, which is a common sovereign citizen belief. The idea is that if they reject federal citizenship, they no longer have to follow state or federal laws. But the judge answers with a simple example that completely cuts through the argument. If you go to Japan, you're still subject to Japanese law. That response says it all. It doesn't matter how someone labels themselves or what legal theory they believe in. If you're physically inside a country or state, the laws of that place still apply to you. The judge handles the moment with a lot of patience and precision, and it's honestly impressive to watch. Now here's the bigger question for everyone watching. Should judges move quicker when dealing with sovereign citizen arguments? Or is it important to let people fully explain themselves in court? Some judges shut these claims down immediately, while others allow the conversation to continue before ruling. There are valid points on both sides, so drop your thoughts in the comments and let us know where you stand.
Michigan Constitution. Now, I realize that because you cited the 1850 Michigan Constitution. In this court's eyes, I believe it's the 1963 is the date. Don't hold me to that exact date, but the latest version of the Constitution. When citizens are able to pick and choose which things they agree with in the Constitution and which things they don't agree with the Constitution, that's where things run afoul. And that's where it takes a court a lot higher than me to make that decision. So it's a long-winded way of saying is I am only going to be bound by what is appropriate for this court. If you need to take it to higher courts, that's certainly your prerogative. But moving forward, can you at least agree to that?
Okay, so from what I remember is that the judge or the prosecutor, depending on how they file it, in which the prosecution filed it incorrectly, especially after finding out about my nationality status. Nationality status is protected by the Constitution, and the Supreme Court has ruled on that.